Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from the law offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 2 immigration shows every week on Wednesday with Prashanthi Reddy at 5:30 p.m. EST in English and on Friday at 6 p.m. EST with attorney Bhanu Elendra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to readyesq.com for contact information, and when you connect with them, don't forget to mention Sakshi TV. From the beginning, readyesq.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The readyesq.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Hello Prashanthi, welcome to the show.
Hi Tony, how are you?
Very well, thank you. How are you?
I'm good, thank you.
Right, so today's topic is the H1B FAQs, and we will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. So, Ms. Reddy, we have, since the topic today is H1B FAQs, we have some FAQs from our viewers. So before we get into that, do we have any latest immigration updates that you'd want to share with our viewers?
I think we should just jump into the frequently asked questions.
Right. So the first question is, a person. So this person is, I'm currently on 9th year extension of H1B. Is there any possibility to shift to another, shift to a different company? And if yes, what is the procedure?
Yeah, that's a good question. So, in general, you get a H1 only for 6 years, but you can get an extension beyond 6 years under certain circumstances. So, in order to get, and this is a relatively new law, but maybe 4 or 5 years old, but in order to get an extension beyond the 6 years, you should have a labor certification pending for at least 365 days. Or a labor certification plus the second step of the green card, which is the I-140, pending for at least 365 days. And if that is the situation, then you get an extension for 1 year on your H1. So you'll get extension from 6 years to 7 years, to the 7th year. And another way of getting it is if your I-140 is approved. If your I-140 is approved, then you will actually get a 3-year extension. On your H1, so you'll get an extension for 3 years. And also, if your 6 years gets over, and if you leave the country, and if you stay out of the country for a year, then you get a fresh 6 years H1 period. So, but the only problem with that is then you'll be counted against the cap. So, and another way of getting, I think another way that I need to mention to get extension beyond 6 years is also by counting the days that you spent outside the country. So you can recapture the days that you spent outside the country. Say in the last 6 years you spent 1 month outside the country, so you have 6 months that you can recapture. So you have more time that way to then file your labor and hopefully get the I-140 approved. Now, the labor usually takes 6 to 8 months. So you have to plan it properly, and the I-140 takes, you can file premium processing, and it can take as less as 30 days to get approved. So, that in a nutshell is how you can apply for a H1 beyond 6 years.
Right. Right. So the next question is from another viewer. So he or she says that after the 6-year H1B period, what if I'm not eligible for the 6th year extension? What are my other options? Should I or can I switch to F1 or any other status?
Right. A lot of people find themselves in this predicament because they don't start the green card process on time. It could be that their company doesn't want to file their green card. A lot of MNCs don't like to file green cards. Or it could be that they just changed too many times, so they didn't have time to, they didn't stick with one company to uh, for there to be enough time to file the labor in the I-140. Whatever the reason might be, or maybe they tried but failed, but whatever the reason might be, once your 6 years is up, and if you're not eligible for any of the procedures that I mentioned earlier, then you will find yourself in trouble. So you cannot stay in the country anymore, at least on a H1. So either you'll have to leave the country and then file for your labor, file for an I-140. Once it gets approved, then you can come back on a further extension on your H1. Otherwise, it's possible to change to an F1 or a B2, which is a visitor's visa. F1 is a student visa. Or you could even, if your spouse is on a H1, you could change to a dependent visa. So if your spouse is on L or a H1, you can change to a H4 or an L2. So dependent visas. So then what will happen is you will change to a different status, and then you will apply for the labor and I-140. While that's pending, you will remain on this other status. And once the I-140 gets approved, then you can again switch back and file a change of status to a H1.
Right.
So it might be difficult for you to travel during this time because a lot of these visas, the F1 and the B2, don't allow you to extend or travel once you filed an I-140, because that's an immigrant petition. And to be in any of these statuses, you have to show that you do not have the intent to immigrate. So you have to file it before the I-140 is filed, so that you don't have to answer that question. Have you ever filed an immigrant petition before? There's a question in the I-539 when you file a F1 or a B2 or a B1. So you can answer that as no, because a labor cert does not count as an immigrant petition.
Right.
But you can file it, and then, after that, file the I-140 while, your change of status is pending. But travel or extension will be a problem.
Right. So, Ms. Reddy, moving on, we have a caller on hold, Mr. Shiva from Texas. Thank you for calling, Shiva. You may ask Ms. Reddy your question directly.
Oh, sure. Thank you. Thank you, ma'am. How are you, ma'am? This is Shiva in Telugu, Texas. I have a question. So here's my situation. I have a daughter who is aging out in 10 months, and she's in first year in the college right now, and she'll be going for second year next year. And let's say I apply for the F1 visa now, and if it is pending, and in case her H4 is expired before F1 gets approved, and if she turns 21, can she continue the college in pending F1 status, or do we need to wait until F1 to get approved, then only she can continue the college?
So, with reference to the more important question, whether she can stay in the country, yes, she can, while the change of status is pending. And you're applying now, so 18, that's 2 years. So even if, given the backlogs with USCIS, it's a good thing that you're applying earlier, but still, it should take 12 to 18 months. It shouldn't take 2 years for the F1 to get approved. With reference to continuing in school, while the change of status is pending, a lot of DSOs will accept, a lot of colleges will accept you as a student. So, and remember, you can work on a H4. So, but I understand your question. Once the H4 expires, then what happens? Then you're in pending F1 status, and you need to speak with your school DSO to find out whether, you can continue school or not. And you should do that now before applying and before starting the process. Some schools do allow it.
Oh, okay. So that is not that's all based on the college, whether they accept the pending F1 status or not, right?
Correct. Yes. As long as you're not out of status, so you have a pending status. Yeah.
Yeah. If I apply for my 485, my date is not current, and if I include her, and if I don't apply for the F1, and can she attend the college based on the pending 485 status?
No, you need to have a EAD to apply to go to college. So the EAD should have been approved. And if you file while she's still, if you file based on final action dates when she is 18, then remember, even if she turns 21, she will still get the benefit of getting the green card. Only if you do it based on the final action dates.
But I said, like,
So she will not,
she will not
age out. Yeah, what I'm saying is she will not age out.
Right, but age will be locked, but we don't need EAD to continue the college, right? Only for the internship we need EAD. But based on the pending 485 status, she can still enroll in the college in the second year and she can continue. Is that right?
No, you need a EAD. You have to show them something. So it's just a pending 485 otherwise. Pending 485 doesn't give you any status. So you have to have the EAD allows you to work or study or do all those things. So you need actually to have the EAD approval.
Oh, okay. Sure. Okay, thank you very much, ma'am. That's what I have.
You're welcome.
I hope that answered your question. Thank you for calling, Shiva. Miss Reddy, we have another caller on hold, Mr. Sam from Chicago. Thank you for calling, Sam. Hope you're doing well. And you may ask Miss Reddy your question directly.
Hi, how are you? My name's Sam. So I have one quick question. Like my priority date is 2013 June, which is currently in this coming April. And I filed EB3 and I got my EAD and AP. So I joined my new company and they filed my I-114 EB3 and because the date was current at that time. So my previous company had a I-140 EB2, which that's an old company, but the new company filed straight EB3 and it got approved in EB3 I-140. So the date is current and I'm planning to apply a new I-140 and so is there anything I can apply in a premium process because my firm got approved like it's more than 6 months and if I apply now the USCIS will accept my premium process because they don't have original labor certification. So is it a good idea to file as a premium or just file as a regular process once I get a receipt and apply in a premium process? That's the one option. I mean, I just need your advice on that. And once I get an approval of I-140, can I do an interfile or refile? Because my case is in NBC Center. So I completed recently my GC interview and it's done. And after interview, I got my 485J approved. So these are the two questions of what you suggest on me.
With reference to filing for EB2, that is presuming your perm is approvable under EB2, say the perm was originally filed for a master's or a bachelor's plus 5, if that's the minimum requirement, then you qualify to file under EB2 even though the perm has expired. But there is a question of whether you can file premium processing or not. Sometimes they accept it and sometimes they don't. If they're able to find the perm original approval and pull out your file, then they would most probably accept it. If they're not able to, then they might deny it and then you can resend after a few months. So there's no harm in filing it initially under perm and seeing what happens. And if it gets denied, then again, waiting for a few months and then trying again to file under perm. That's the instructions that they've given anyway to do that. So that's the answer to your first question. And what is your second question?
So let's say once my I-140 got approved, and do you want me to interfile or refile my 485 in EB2 because currently it's in EB3?
Right. So that is again a good question because everybody is asking that same question, and the best thing to do would be to do both, right? What are you're losing the money. If you interfile, the advantage is, and if they accept it, it's not just you interfiling, they have to accept the interfiling, and that is discretionary. That's up to them to accept or not. So if they accept that, then obviously you are better off if they accept your interfiling, nothing like it. because then your processing time has already reached, towards the end of the processing time, because you've been interviewed, etc., etc. But if they don't accept, of course, then it's back to square one again. So that's why you could. That's why people refile. The disadvantage of refile is you have to pay 12.25 for each application again, plus the processing fee, and plus the attorney processing fee, and you also then have to wait, because again you're filing a new petition, so your processing time the clock starts right from the beginning again. So a lot of people are doing both, and some of them are just doing interfiling to see what happens, because remember, we don't know what's going to happen with EB2 and EB3. Things might just turn around because everybody's filing EB2 petitions now. So might not be a bad idea to have both EB2 and EB3 485s. And then you can decide which one to keep. The USCIS has been very clear. They're trying to discourage people from filing two 485s because it's a lot of work for them and they don't want duplicate filings. But, if they show that they're making some headway with the interfiling requests, at least we can, properly advise clients, and, you can get a better idea as to what to do. So far we've done a lot of interfiling, but we have not received any approvals as such or any responses from the USCIS stating that they have approved the decision or they're looking into the decision. We have not received anything. So we're just waiting for now and advising clients, as we should, to do everything possible.
Right.
Use all your options.
Okay, thank you.
I hope that answered your question, Sam. Thank you for calling. So, Ms. Reddy, moving on to our H1B FAQs, my next one is there a possibility for an H1B, holder to start a firm or a business with a citizen and then transfer that H1 to that company?
Right. This is a lot of what our clever IT people ask us, because they're trying to find ways and means of, remaining in status, because, USCIS makes it so difficult sometimes. You follow all the rules, but you still are not able to maintain status. And this gives them some amount of power over their own H1. Otherwise, they're at the mercy of their employers. So the short answer to that is no. Simply because if USCIS comes to know that you are the employer and the employee at the same time, even though employer-employee relationship, that was a big issue and it's no longer an issue, but still they will not allow you to file a H1 from your own company, because it's difficult to show that you actually have a valid job offer with with an employer, because you are both the employer and the employee. So I doubt if they will approve such a H1. And though recently, on and off, we've been hearing from USCIS that it's possible, and there have been some statements about self-petitioning H1s. Right. But as of now, we don't have any specific guidelines, and I don't think it'll get approved if you try to do that.
Right. So, Ms. Reddy, we have another caller on hold, Mr. Kumar from Texas. Thank you for calling, Kumar. Hope you're doing well. You may ask Ms. Reddy your question directly.
Hi, Prashanthi Reddy. Thanks for your help on our community. I have a question. My priority date is August 2011, and in 2020 October, my employer went to downgrade with a successor in interest. So I received a EAD and AP, but it's in a Texas service center. As of now, no movement. And I filed in medical center filing, but I don't know whether it is attached. So now USCIS is requesting to transfer the underlying EOS to the EB2. So I checked with my lawyer, then they said, we need to do another EB2 successor and interest, I-140. So my question is it a good idea, or can I stay with in EB3 are they going to issue the EB3 or, can you do the interfile into the EB2?
So you have two options. You can interfile. You have three options. You can interfile, and yes, you have to show the successor in interest. And I would just, submit the same documents that you submitted last time for the I-140 just to show, successor in interest, and do the interfile as well. Because you already have an EB2. Only thing is, I guess it's with a different employer, and that company is bought over by this new employer. So you could do that. There's no harm in doing it. If they approve it, well and good. If they don't, they don't. You could attempt to do the interfile because it doesn't cost anything, right? And second is, what you can also do is refile your EB2, refile your 485 with the EB2, and do the successor in interest documentation there as well. So you can file a new petition. I think you can do both, because in your situation there's also a successor in interest situation, but there's no harm in trying to do both.
In EB3, if I mean EB3, so there is it will not be any movement in the future until October. So do you need to
So we don't know. We don't know. Most probably there will be, because this is a cyclic thing, right? Sometimes EB3 moves forward, then EB2 filings, they become too many, then again EB3, nobody is filing in EB3. So there becomes availability in EB3. So if it follows a pattern, and you can just notice the last 5 years what has happened. Right, in October, EB3 was ahead and EB2 was behind. So this will be a pattern which will continue. There's no doubt about it. You also have to remember that most of our IT professionals have master's degrees. So most of them, if they qualify, everybody will file under EB2. There's no reason. There is always more EB2 filings than EB3 filings, traditionally, because more people qualify.
My lawyer is saying a new I-140 is required for the successor of interest under EB2. So that's what my
I understand that. I understand that, but but you're talking about interfiling. For interfiling, there's no harm in just putting the successor and interest documents and asking for an interfile request with just the I-140. There's no need to do a 485 for the interfiling. You can do it that way. You can do an interfiling with just the I-140 being refiled, amended under successor of interest. You're not downgrading or not doing anything. You have an existing.
That means a new I-140 successor of interest. Is that correct?
Yeah, I mean you have to amend the previous. It's not a new. It's an amendment. Your previous EB2 you're amending to the new company.
Oh, okay, got it.
And you're interfiling at the same time.
Okay, will do. Thank you, ma'am.
You're welcome.
Right, thank you for calling. So, Ms. Reddy, getting back to our H1B FAQs, my next question is, can a person apply for 2 H1B transfers at the same time?
So again, a lot of employees, because the market is good and they're in demand, especially the senior people, they might, and also because they're not sure which H1 will get approved, they might accept 2 job offers at the same time, and then 2 H1s might be filed for them. Maybe they're working for company A, and perhaps they're transferring their H1 from company A to company B and then company C as well. In this case, yes, it can be done, but there's something called the last action rule. As per the last action rule, that case which is filed last is the one that is will be taken into consideration by USCIS, because that's your last request. So if you file the C company H1 a few days after the B company H1, and if both get approved, then you will be considered to have transferred your petition to company C. So if before it gets approved you withdraw one petition, say you withdraw C before it gets approved, then of course the only remaining petition is B, and so B will be taken into consideration, and when it gets approved, then the person will be considered to have transferred to B.
Right, okay. So moving on to our next question. I am an L1 H1 I'm on L1 H1 visa. So can I start a business of my own, and do I need a green card to start a business here?
Right. So they're basically saying they're either on H or L, whatever the status is, and they want to start a business on the H or L, because I don't blame them. Green cards are taking forever, especially for Indian nationals, and all our, our people are very entrepreneurial. This question is very valid. So you don't actually need a green card to start a business, but you do need an unrestricted work visa. So a H and a L are restricted work visas, because you're only allowed to work with the company that has filed your H or L. You're not allowed to do anything else. But instead, if you have a L2 EAD, like you're a dependent of the L, or you're a H4 EAD, employment authorization, or you have EAD through some other means, like you're a student and you have EAD through optional practical training, then you can work. You can work for any employer and maintain your status as well, because an EAD is not restricted to one particular employer. Otherwise, I'm afraid that you will be not maintaining your status if that's all you're doing. You're starting your own business and you're working for that business. You'll be in violation of your status.
Right. Okay. So moving on to our next question. I have transferred my H1B to another company and I worked with them for a few months now, but I'm not happy. So can I go back to my old employer given that he's not cancelled my H1B yet?
Yeah, this is again a controversial question as to, once you filed a transfer, does the previous H1 get voided somehow because you've requested something and the USCIS has accepted it? And the answer to this is yes, you can go back to your previous employer as long as they have not cancelled your H1. And as you said, you filed the H1 transfer, it got approved. The previous employer has not cancelled, you can go back to that. So it is still kind of a gray area, but I think USCIS has allowed this in the past, and I've never seen them go after people for violating their status based on this. So I safely say that you can. But you have to remember that when you transfer from company A to company B is required to cancel your H1. So most often than not, they will. But for some reason, if they haven't, then yes, you can go back.
Right. Right. So I think with that we come to the last question of this session. So if I'm planning to transfer my H1B to J1 visa, then will I get 6 more years granted after my J1 expires?
Yeah, so this they're asking this because they think that if you leave the H1 visa and work on another visa for 1 year, then you might get again a fresh 6 years on H1. That's not the case. You have to actually leave the country and stay outside the country for a year. You can go to Canada or Mexico and stay there for a year. Only then you will get 6 more years on your H1 status, not if you change status within the US to a J1 or L1 or whatever.
Right. So with that, Ms. Reddy, we come to the end of this session. We've got some callers and questions from our viewers. Hopefully we can continue all the other questions for our next session next week. It was a pleasure hosting you, Ms. Reddy.
Thank you. Take care,
Thank
Dharani.
you so much. You're watching Sakshi Live and this is Torani.